take away your constitutional rights under the Second Amendment. Well, we just heard that that's exactly what the Democrats want to do here today.
Is consistent with the historical tradition of the nation's regulation of firearms.
You can't protect yourself with a 9mm, I guess, according to Biden, only a 22.
The reason I invented the brace was for people with limited mobility. Well, that was the inception. That was why I made it.
Millions of firearms that Americans legally own today will be illegal.
The Supreme Court has issued a monumental and surprising ruling that is reshaping firearm regulations throughout the U.S. Let's delve into the details to uncover the recent developments. A watershed Supreme Court ruling. In a landmark decision by the U.S. Supreme Court pertaining to the Second Amendment, a seismic shift is occurring in firearm regulations across the nation, causing division among judges and casting a cloud of uncertainty over the viability of various firearm restrictions. The High Court's ruling, which introduced fresh criteria for evaluating gun laws, has given rise to a multitude of perplexing issues, as legal experts observe a growing number of contradictory verdicts emerging from lower courts, with judges grappling to decipher its application. The Supreme Court's much-discussed Bruin verdict has altered the litmus test that lower courts have traditionally employed when assessing challenges to firearm restrictions. The justices have decreed that judges should no longer weigh whether these laws serve the broader public interest, such as bolstering public safety. Under the Supreme Court's novel standard, any government seeking to uphold a gun restriction must delve into the annals of history to demonstrate its compatibility with the nation's historical tradition of firearm regulations. In recent months, courts have invalidated federal laws designed to prevent firearms from falling into the hands of domestic assailants, individuals facing felony charges, and those who use marijuana. Judges have nullified a federal ban on the possession of firearms with removed serial numbers and have overturned firearm restrictions targeting young adults in Texas, while also thwarting Delaware's prohibition on homemade ghost guns. In a series of instances, judges, when confronted with the same legislation, have arrived at divergent conclusions regarding their constitutionality, following a ruling by the conservative majority in the Supreme Court. The legal tumult spawned by this decade's initial major gun-related ruling is likely to compel the Supreme Court to intervene once more in the near future, offering clearer directives to the judiciary. Jacob Charles, a legal scholar specializing in firearms law at Pepperdine University's School of Law, remarked, "The lower courts are beset by bewilderment and disarray. They not only fail to reach consensus, but also apply distinct methodologies or interpret the Bruin framework disparately."
Take away your constitutional rights under the Second Amendment. Well, we just heard that that's exactly what the Democrats want to do here today.
We will undoubtedly hear a variety of arguments from our Republican friends opposed to taking these deadly weapons off our streets.
This has led to the annulment of not just new laws, but also statutes that have endured for 6 decades, and in some instances, 40 years. Prior to Bruin, these statutes enjoyed unanimous constitutional validation. This legal quagmire unfolds against the backdrop of persistent mass shootings that continue to afflict the nation amidst a proliferation of firearms, while law enforcement agencies nationwide grapple with surging violent crime rates. In the early months of 2023, a rural Mississippi town witnessed multiple fatalities due to gunfire at various locations, while a lone gunman tragically claimed the lives of 3 students and left 5 others critically wounded at Michigan State University before taking his own life. Throughout 2023, numerous lives have been lost in mass shootings, including a tragic incident in California where 11 individuals were fatally shot during a Lunar New Year celebration at a dance hall frequented by older Asian Americans. The Gun Violence Archive recorded over 600 mass shootings in the U.S. last year, involving at least 4 fatalities or injuries in each incident. The ruling has created an avenue for an onslaught of legal challenges from advocates of gun rights who perceive an opportunity to overturn laws encompassing a wide spectrum, ranging from age restrictions to semi-automatic firearms of AR-15 style. For proponents of gun rights, the Bruin decision has been a welcome development, viewed as a removal of purportedly unconstitutional constraints on Second Amendment rights. As the recent decision invalidated New York's legislation restricting concealed carry of handguns, it has paved the way for challenges against other gun control statutes. A Supreme Court ruling affirming the Second Amendment's protection of the right to own suppressors would mark a significant triumph for advocates of gun rights. Nationwide eruptions of fury. Gun control advocates are sounding the alarm bells in the wake of a 2023 federal appeals court ruling that has sent shockwaves across the nation. This decision, based on the Supreme Court's revised criteria, has granted individuals with domestic violence restraining orders the right to own firearms, leaving many deeply concerned. The Fifth U.S. Circuit Court of Appeals in New Orleans, while acknowledging the law's intention to protect society's most vulnerable, shockingly found the government lacking a historical precedent from early American history that sufficiently aligns with the modern law. Attorney General Merrick Garland has vowed to relentlessly pursue further review of this contentious decision, but the implications are ominous. Amid this turmoil, proponents of gun control express their vehement opposition to the Supreme Court's historical litmus test. They assert their unwavering confidence that numerous gun control measures will withstand these turbulent times. Despite the recent ruling, federal judges continue to uphold the ban on firearm possession for convicted felons. The Supreme Court has underscored that matters involving unprecedented societal concerns or dramatic technological changes may necessitate a more discerning approach. Shira Feldman, litigation counsel for Brady, the gun control organization, affirms that the right to bear arms is by no means absolute and is confined to law-abiding citizens. The Supreme Court's criteria have ignited a fiery debate surrounding the suitability of judges to navigate the annals of history and to gauge the relevance of past regulations in the context of modern laws.
Is consistent with the historical tradition of the nation's regulation of firearms.
When an assault weapon is used during a mass shooting, 6 times as many people are shot.
We are far from experts on the perspectives of white, wealthy, and male property owners regarding firearms regulation in 1791, yet we are now thrust into the role of historians in the pursuit of constitutional interpretation, thundered Mississippi U.S. District Judge Carlton Reeves, a nominee of President Barack Obama. The nation's attention remains fixated on a series of pending cases that could shape the future of firearm rights and gun control. Among these cases are challenges to state laws prohibiting specific semi-automatic weapons and high-capacity magazines. In a recent Chicago ruling, a federal judge vehemently upheld an Illinois law banning the sale of so-called assault weapons and high-capacity magazines, deeming it constitutionally sound under the Supreme Court's new litmus test. However, a state court has partially halted the law's enforcement, allowing some gun dealers to continue selling these weapons amidst a separate legal battle. The fallout from the Supreme Court's decision is already evident, with some gun laws crafted in its aftermath being struck down. A judge in New York declared several provisions of the state's new gun legislation unconstitutional, including restrictions on carrying firearms in public parks and places of worship. An appeals court has temporarily suspended that ruling while reviewing the case, permitting New York to enforce the law for the time being. The judicial landscape is a battleground, with some judges upholding laws that bar individuals under felony indictment from purchasing firearms, while others declare such laws unconstitutional. In a California case, U.S. District Judge George Wu, nominated by President George W. Bush, couldn't resist taking a pointed jab at his fellow judges' interpretations of the Supreme Court's guidance. The entity that initiated the challenge, and seemingly a few other courts, seems eager to treat the Supreme Court's decision as a mere word salad, cherry-picking elements to concoct an entirely bulletproof and unrestrained Second Amendment, noted Wu in his ruling, casting a shadow over the ongoing legal turmoil. Public gun carry rights in the U.S. The issue of carrying firearms in public within the U.S. has been a contentious topic in both political and constitutional circles throughout the 21st century. Prior to a pivotal case, the Supreme Court had rendered 2 significant judgments concerning gun possession within one's home. In District of Columbia v. Heller, it affirmed that U.S. citizens possessed an individual right, distinct from a well-regulated militia, to own firearms within their residences under the Second Amendment. Subsequently, in McDonald v. City of Chicago, this right was upheld as applicable to states. However, the matter of firearm ownership beyond one's abode had yet to be addressed by the Supreme Court, resulting in a patchwork of state laws and federal court decisions governing the issue. These determinations were primarily founded on historical common law, allowing the government to regulate firearms in public spaces to uphold state regulations regarding public gun possession. Over the course of more than 1,000 cases since Heller, most federal appeals courts utilized intermediate scrutiny, rather than strict scrutiny, when assessing the constitutionality of public carry gun control laws, recognizing the state's compelling interest in safeguarding public safety through restrictions on gun possession in public areas. To address rising criminal violence in specific New York City neighborhoods, including the assassination attempt on Mayor William J. Gaynor and the killing of author David Graham Phillips, Timothy Sullivan spearheaded the enactment of the Sullivan Act in 1911. This legislation criminalized the possession of handguns without a permit and introduced the issuance of concealed carry permits at the discretion of local law enforcement. According to the law, applicants had to demonstrate a special need for self-protection distinguishable from that of the general community or of persons engaged in the same profession. It was clarified that this need had to be grounded in real self-defense requirements to establish a legitimate cause for granting a permit. The New York State Rifle and Pistol Association, along with Robert Nash and Brandon Koch, who were denied permits in New York, challenged the law, aiming to eliminate the discretionary aspect of permit issuance. For instance, Nash sought a permit for a handgun following a series of robberies in his neighborhood, but was refused as he could not substantiate a need for self-defense. The plaintiffs argued that the law and permit denials were flawed, contending that good, even impeccable moral character plus a simple desire to exercise a fundamental right is, according to these courts, not sufficient, nor is living or being employed in a high-crime area.
The American people want their constitutional rights protected and their kids to be safe in school.
If the ban had remained in effect, 70% of the families torn apart by these massacres would still have their loved ones today.
The Sullivan Act is considered the first may-issue public carry law in the U.S., as it vests discretion in evaluating an individual's need to carry a gun in public, a framework later adopted by 7 other states from New York. This contrasts with more recent shall-issue licensing requirements, which rely on objective criteria such as background checks and aptitude assessments to determine eligibility. The petitioners implored the Supreme Court to review their case, with a particular emphasis on the question of whether the Second Amendment permitted the government to restrict ordinary law-abiding citizens from carrying handguns outside their homes for self-defense. The Supreme Court granted certiorari on April 26, 2021, although it narrowed the scope of the case to focus solely on whether the state's denial of concealed carry licenses for self-defense violated the Second Amendment. On November 3, 2021, the case was heard, marking the Supreme Court's first major engagement with gun rights in over a decade. It was also the inaugural gun rights case to be heard by the 6-member conservative majority, featuring Justices Clarence Thomas, Neil Gorsuch, and Brett Kavanaugh, who had previously underscored the necessity for the court to re-examine its stance on Second Amendment cases. The court delivered its verdict on June 23, 2022. In a 6-3 decision authored by Justice Clarence Thomas, the court declared the state law unconstitutional as it encroached upon the right to possess and carry firearms, overturning the Second Circuit's ruling and remanding the case for further review. Justice Thomas, joined by Chief Justice John Roberts and Justices Samuel Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, effectively established public carry as a constitutional right under the Second Amendment. Thomas asserted, the constitutional right to bear arms in public for self-defense is not a second-class right subject to an entirely different body of rules than the other Bill of Rights guarantees. We know of no other constitutional right that an individual may exercise only after demonstrating to government officers some special need. The court's decision in the Bruin case marked a significant victory for advocates of gun rights. It overturned a long-standing precedent that had permitted states to impose stringent restrictions on concealed carry of firearms. Furthermore, it paved the way for challenges to other gun control laws, including prohibitions on other weapons and high-capacity magazines. Reactions to the Bruin decision have been mixed. Supporters of gun rights have lauded the ruling, arguing that it safeguards their Second Amendment rights. Conversely, advocates for gun control have criticized the decision, expressing concerns that it may facilitate easier public gun carrying and potentially contribute to an increase in gun violence. Attorney General takes legal action. In an intriguing turn of events, Texas is making a bold move that could potentially allow its residents to manufacture firearm suppressors without navigating the federal bureaucracy. Texas Attorney General Ken Paxton has initiated a lawsuit against the ATF with the aim of halting federal oversight on silencers produced within the state. The lawsuit argues that federal laws and regulations, which impose taxes and restrictions on the creation of firearm suppressors in Texas for personal use within the state, infringe upon a fundamental right protected by the Second Amendment. The catalyst for this legal battle is House Bill 957, sponsored by Representative Tom Oliverson, which seeks to exempt Texas-made suppressors from federal regulations. Since the implementation of the National Firearms Act in 1934, prompted by notorious criminal incidents like the St. Valentine's Day Massacre, citizens have been required to pay a $200 tax stamp fee to the ATF for the privilege of purchasing suppressors. Federal regulations also mandate the registration of suppressors in a national database. Manufacturers must hold an ATF license to produce suppressors, and even individuals desiring to create suppressors for personal use must navigate the tax stamp process and secure prior approval from the ATF. However, HB 957 asserts that these regulations should not apply to suppressors manufactured in Texas. It bars state and local law enforcement from enforcing federal suppressor regulations. To avoid putting ordinary citizens in legal jeopardy with the ATF, the law initially tasks the Texas Attorney General with seeking a federal court declaration that HB 957 is constitutionally sound, acting on behalf of a Texan who wishes to craft a Texas-made suppressor. Despite the passage of HB 957, the ATF issued a warning to licensees in Texas, signaling its intent to continue enforcing federal laws. Several months passed without action from Attorney General Paxton, causing many suppressor companies in Texas to doubt the effectiveness of HB 957. Given the risk of losing their licenses for violating the NFA, one business owner suggested that an individual should reach out to Paxton and challenge the law. Paxton ultimately filed his lawsuit on behalf of 3 Texans who expressed their intention to create suppressors for personal use, restricting them to Texas. These individuals argue that suppressors would enable them to defend their homes without using earplugs, allowing for greater alertness without the risk of hearing damage. Dr. Oliverson, a medical practitioner and sponsor of the bill, presented similar arguments during the bill's discussion in the Texas House. In his legal brief, Paxton contends that the federal government lacks a compelling interest in regulating suppressors that could outweigh the protections afforded by the Second Amendment and established legal precedent, such as D.C. v. Heller. Paxton specifically highlights that the $200 tax stamp fee fails to generate revenue sufficient to cover the cost of collection, and that suppressors do not present an obvious criminal threat, unlike items like grenades. The lawsuit criticizes the inclusion of suppressors in the NFA as a historical accident, noting that the $200 fee was set based on the average cost of a machine gun at the time.
You can't protect yourself with a 9mm, I guess, according to Biden, only a 22.
Mass shootings have increased exponentially in our public spaces, schools, movie theaters.
Furthermore, the NFA definition of a firearm excludes most common long shotguns or rifles, but includes suppressors and their components if intended for suppressor construction. Paxton argues that this makes little sense, as a metal pipe becomes a firearm subject to taxation and regulation under the National Firearms Act of 1934 if the owner intends to incorporate it into a firearm suppressor. Other metal pipes are not categorized as firearms under the statute, according to Paxton. Remarkably, among all the items governed by the NFA, including short shotguns and rifles, machine guns, and grenades, suppressors stand out as the sole firearm accessory included. Paxton seeks 2 permanent injunctions through his lawsuit. The first aims to prevent the ATF from imposing the tax stamp, while the second seeks to halt the enforcement of federal gun regulations beyond taxation related to the production of suppressors in Texas for personal use within the state. In a broader context, Paxton also seeks a declaration that federal suppressor regulation represents an invalid exercise of power. Gun control proponents argue in favor of government oversight of silencers to prevent them from falling into the hands of criminals. They contend that silencers make it harder to pinpoint a shooter's location, hindering law enforcement response to shootings. Additionally, muffled gunshots reduce the likelihood of bystanders reporting gunfire to the police, according to these groups. However, it appears that most Texans hold a different perspective. In fact, Texas, the second most populous state, led the nation in 2020 in terms of the number of manufacturers and dealers of silencers, as well as other specialized weapons such as short-barreled rifles, short-barreled shotguns, and machine guns, according to the ATF. As of May 2021, Texas boasted the highest number of registered silencers compared to any other state, exceeding 520,000. Florida came in second with over 175,000 registered silencers, while California, the most populous state in the U.S., had just over 17,000 registered silencers. The Second Amendment. In today's discourse, there is a contentious debate surrounding the protection of modern firearms under the Second Amendment of the U.S. Constitution. Despite the arguments put forth by those against gun ownership, it is vital to recognize that contemporary arms indeed find shelter within the Second Amendment's provisions. By delving into the principles underpinning this constitutional right and considering the ever-evolving landscape of self-defense, we can discern the enduring significance of modern firearms. To grasp the applicability of the Second Amendment to modern firearms, it is crucial to transport ourselves back to the historical concept of its inception. In 1791, when the amendment was ratified, muskets and rifles were the prevailing firearms of the era. Critics argue that the framers could not have foreseen the technological advancements in weaponry that we witness today.
The reason I invented the brace was for people with limited mobility. Well, that was the inception. That was why I made it.
10 million felons in the United States because they bought a product that the ATF authorized.
While this assertion holds truth, it is equally essential to remember that the core principles of self-defense and individual liberty enshrined in the Second Amendment remain resolute. The interpretation of the Second Amendment has sparked intense debates, but the Supreme Court has consistently affirmed the individual right to bear arms, distinct from militia service. Landmark cases like District of Columbia v. Heller and McDonald v. City of Chicago underscore that the Second Amendment safeguards the right to self-defense within one's home and encompasses firearms in common use for lawful purposes. Consequently, modern firearms, which are widely owned and commonly employed for self-defense, unquestionably fall under the realm of constitutional protection. Self-defense stands as a cornerstone of the Second Amendment's intent. Modern firearms equip individuals with the means to shield themselves and their families from immediate threats. The possession of firearms with such features as semi-automatic capabilities and larger magazine capacities confers a significant advantage during emergencies. These modern arms empower law-abiding citizens to respond effectively to potential harm, thus bolstering personal safety. By acting as a deterrent to criminals and providing a means of self-defense, modern firearms contribute significantly to the overall security of individuals and communities. The argument against modern firearms often centers on the belief that they are superfluous for self-defense. However, it is vital to note that the Second Amendment does not specify the types of firearms protected, but rather upholds the right to possess arms that are in common use and suitable for lawful purposes. Modern firearms undoubtedly meet these criteria, as they are widely owned and utilized by law-abiding citizens for self-defense, recreational shooting, and other lawful activities. Efforts to restrict or ban modern firearms based on their appearance or capabilities undermine the core principles of the Second Amendment. The focus should shift towards addressing the root causes of violence and crime, rather than targeting the tools used by criminals. The Second Amendment guarantees the right to bear arms, encompassing firearms in common use for lawful purposes. While some argue that suppressors are not intended for self-defense and thus should not be protected, this overlooks their significant practical applications. Suppressors play a crucial role in hearing protection, reducing noise pollution, and minimizing recoil, contributing to safer shooting experiences. Their use in hunting can help mitigate noise disturbances and improve accuracy. As such, suppressors fall within the purview of the Second Amendment's protections for modern arms. Suppressors have often been subject to misconceptions perpetuated by media portrayals and popular culture.
Shall not be infringed unless Democrats say this weapon looks so scary we have to get rid of it.
They want to take away law-abiding citizens' ability to purchase the firearm of their choice.
Millions of firearms that Americans legally own today will be illegal.
Contrary to their depiction as tools exclusively utilized by criminals or assassins, suppressors primarily serve lawful purposes such as recreational shooting, hunting, and home defense. Acknowledging their lawful applications and demystifying their capabilities are crucial steps toward understanding why suppressors should be protected under the Second Amendment. The inclusion of suppressors in the category of modern arms aligns with the objective of promoting firearm safety and accessibility. By mitigating the loud noise associated with firearm discharge, suppressors help reduce hearing damage risks, making shooting ranges and hunting environments safer for both firearm users and bystanders. Their use can make shooting activities more accessible to individuals who may be sensitive to loud noises or have heightened auditory concerns. While acknowledging suppressors as modern arms, it is important to emphasize the need for responsible ownership and regulation. Striking a balance between individual rights and public safety, the implementation of thorough background checks, training requirements, and registration processes can ensure responsible usage and deter misuse. Such measures can address concerns regarding the potential misuse of suppressors while upholding the rights protected by the Second Amendment. In conclusion, despite the arguments made by those against gun ownership, Modern firearms and suppressors undeniably enjoy protection under the Second Amendment. The right to bear arms extends to firearms that are in common use for lawful purposes, including those that have witnessed technological advancements. This recognition of modern arms aligns with the broader advancements in firearm technology while upholding the principles of individual liberty and self-defense that the Second Amendment stands for. That's all for this video, folks. See you next time.